Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear arguments in three cases this morning. First is 21-135 in re Rudolph Automotive, a petition for writ of mandamus from El Paso County and the 8th Court of Appeals District. Then 21-941 PNC Mortgage versus Howard from Calhoun County and the 5th Court of Appeals District. And finally, 21-1063 in re Kapmeyer, a petition for writ of mandamus from Aransas County and the 13th Court of Appeals District. Court has allotted 20 minutes per side in each of the cases and will complete the arguments before lunch. The arguments are being webcast live this morning and will be available later in the court's archives. Justice Lehrman cannot be present this morning but expects to participate in the decisions of all three cases. We're ready to hear argument in 21-135.
May it please the court, Mr. Jefferson will present argument for the relators. Relators have reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court. The plaintiff secured a $4 million verdict after a 3-week trial, but the jury also refused to find that Rudolph Motors was directly liable. More than 4 years ago, the trial court ordered a new trial, adopting verbatim the plaintiff's proposed and flawed grounds. If this order stands, Columbia and Toyota fall. I would like to begin with the plaintiff's oral argument exhibit, which was submitted yesterday. It focuses on Dr. Wimbish's testimony. She argues that because the trial court granted a motion in limine regarding the plaintiff's drinking alcohol prior to the event in question, the trial court properly granted a new trial. Yet, it's important to note that it was the plaintiff's counsel that asked Dr. Wimbish to provide information he had about Villegas's alcohol consumption that was different from what she consumed that night. Now, the trial court remarked that the plaintiff's counsel very widely opened the door on this and invited error. Evidence like this is not incurable if the complaining party invited or provoked it. But any harm was not only curable in this case, but if there was harm, it was cured. The court gave an extraordinary and harsh instruction to the jury. Here's what the court said. You heard testimony from the witness that is not credible, is unreliable, and not evidence in this case. You are instructed to disregard Dr. Wimbish's testimony on all evidence concerning Villegas's prior use of alcohol before this incident. In other words, you can't believe a word he said, is what he was telling the jury about Dr. Wimbish. The trial court then asked each juror individually if they would follow that instruction, and each individually confirmed that they would.
But even that process illustrates that the trial court was somewhat troubled by what happened in connection with that testimony and the reaction that it created. So if the trial court denies the motion for mistrial at that time and then gives the instruction, but evaluates it at the end of the trial and concludes, I should have granted the mistrial, does the trial court have any leeway to do that?
So under this court's precedent, maybe, but it depends on what is the evidence that we're talking about and what would make it incurable. What would make it incurable with the instructions the court gave? Now, this court has said incurable is very rare. It almost never happens. It arises with respect to racial prejudice or unsupported charges of perjury or some
But we say that in connection with a decision in which the trial court has determined that in the exercise of his or her discretion, the instruction cured the improperly admitted evidence. So here we have the opposite. The trial court granted the new trial.
But the evidence, the record shows that if there was any error in Dr. Wimbish's testimony, which they invited, again, you have to recall that under this court's precedent, if they invited or provoked it, it's not preserved. But let's assume that they did preserve it, even though they invited it. Here, the record shows that the plaintiff won anyway, prevailed in this jury trial. And again, I go back to whether it's incurable or not. If it is curable, then this instruction did it. If this court holds that it is incurable and this instruction didn't do it, just imagine what is going to happen. Toyota and Columbia will be a dead letter because this will be the template for new trial, for trials to come. This will be like new trial is granted in the interest of justice and fairness, which is what the Toyota court in Columbia said. That's not enough. If this works in a 6-week trial or a 3-month trial, there's always going to be some
Why would a
objection.
district judge want to redo a 6-week or a 3-month trial? I always thought the district judges would say, even if there was an error, to send it to the Court of Appeals, Supreme Court, and say, go ahead and reverse it, but please don't make me do a new trial. That's the lore, at least. Why would when a district judge says, I want to redo a 3-week, 6-week, 3-month trial, that seems more of a man bites dog kind of story. Why wouldn't we credit that?
Well,
just for that reason alone?
it's when a court abuses its discretion. And here, the trial court, first of all, gave the plaintiff's charge, gave the plaintiff's instruction, and now gave a new trial based on verbatim arguments that the plaintiff presented to this court. And so there are going to be instances. Flores, way back when, that set the standard for new trial in the interest of justice and fairness. After you saw that, you saw it repeated time and again, where after months or weeks or sometimes even longer of trial, the trial court gets rid of the jury's verdict and makes the court waste its time. The jurors have wasted their time. All the witnesses have wasted their time. Memories fade. This trial was back in 2018, I think. It's almost 2 years at the Court of Appeals, and now we're going to do it all over again. If you read Chief Justice Alley's dissent, I think it gets to the core of why you will, and you've ordered the examination of the excuses like this for new trial.
It would not have been wrong for the judge to have granted the mistrial, or would it have been, if the judge had the colloquy, which Justice Blaine says I read that, he was very, very upset by what had happened, it sounded like to me. Polled the jury, gave that very harsh instruction he described, polled the jury, everything happened the same. If at the end of that he had said, I just can't do it, I'm going to have to do a new trial, I'm going to grant a mistrial, and we're going to start fresh, would that have been something that was a legal error?
So I think it would have been another abuse of discretion. And one thing that we haven't, that this court hasn't talked about yet, is in that instance, where a mistrial is granted in the middle of trial, must the trial court provide reasons, just as it would in a new trial. But remember, this happened at the end of this 3-week trial. So all of this testimony had taken place. Witnesses have been, up and down. And that's an open question, I think, whether mandamus would have been appropriate for a mistrial granted at that time. The problem with that is, the jury is gone by the time mandamus is decided, so there's probably very little way to correct that error. But here, the trial was over, and the trial court, yes, the trial court was concerned, and I get that, and that is in the record. But the trial court also recognized that it was plaintiff's counsel that opened the door to this testimony. And so the trial court is thinking, are we going to really waste all of these people's time for something that you provoked to come into the record that didn't even impact the verdict?
Couldn't plaintiff's counsel have assumed that the in limine instruction would be followed?
Yes, and should. I mean, you should always expect that and respect the trial court's orders. The new trial here was not based on the violation of a motion in limine. And not every violation of a motion in limine causes error. In fact, you've got to preserve it down the road later. The point that I'm trying to make here is if this is incurable like a racial epithet or allegations of or improper insertion of insurance and that sort of thing, these rare instances, then what you have held about new trials goes away. And I think that's the problem.
If we agree with you and grant you your relief, the relief that you've requested, the trial court will proceed to a final judgment. And is it your position that your client won't challenge that final judgment on appeal based on some other errors that the trial court did not identify?
If we receive the relief that we're requesting here, yes, it'll go back down for the trial court's entry of judgment. If the trial court follows what the jury did and what the evidence shows, the trial court is going to say that this no answer, in fact, the jury basically 3 times said Rudolph Motors is not negligent in question.
Well, a failure to find negligence is not a finding of no negligence.
That's correct. But the jury refused to find that they were negligent.
But wasn't one of the employees submitted and the jury found that that employee was within the course and scope? So will there be vicarious liability for Rudolph?
Yes, there could be.
But you would challenge that if the trial court rendered judgment on that basis against your client?
Well, I don't know that we would. I don't know that we would. I mean, that's something that we would have to consider, but that is another way to look at this. If you look
Well,
at
that's my concern. If the end result is a new trial after final judgment and on appeal, aren't we right back to where we are right now with the trial court ordering the new trial instead of the appellate court?
I'm not sure why there would be a new trial.
Okay.
So you won't be asking for a new trial?
If the court does what I think the court should do, which is to say,
Our court or the trial court?
the trial court, okay. So if you agree with our proposition that these reasons are invalid, they do not support a new trial, then it goes back down, right, to the trial court. And the trial court is going to need to enter judgment. What is the trial court going to enter judgment on? As we stand today, Rudolph Motors has not been found negligent. The jury answered no with respect to Rudolph Motors twice, and a third time, if you consider question 6, that looked at whether they were serving alcohol as a Rudolph Motors function.
Right,
So
but as we discussed, there could be a judgment against you for vicarious liability for the...
Well, there's a judgment against, there's a verdict against Flores, but Flores has been non-suited. Flores is no longer in the case. And there's a percentage far lower than 50% anyway with respect to that. So I'm not here to tell you that there would be an appeal of what we think would be a judgment favorable to Rudolph Motors.
Is the J&OV still live?
So the judge, if the court,
Would it be if we grant you your relief?
I think so, because it would go back down, it would be as if we're back in the status quo. A verdict has been decided by the court, by the jury, and the court is going to have to decide what to do with that verdict. Under 329B, there will be motions for new trial, probably motion for J&OV on both sides. And if the court were to grant a new trial, then we would test the reasons for that new trial under whatever different reasons that the court came up with. But at this point, what we're saying is that these 4 reasons that the court articulated here, they just have no basis in the record. And under Toyota and Columbia, it means that this new trial is wrong and was an abuse of discretion.
But it couldn't be harmless if you think there should be a new trial for a different reason.
No, I mean, and who knows what the trial court would do if there ought to be a new trial for a different reason. But Rudolph Motors, the very first instruction laid out their theory of direct liability against Rudolph Motors. Our contention is this was an after-hours event. This was not sponsored. There was no direct negligence on Rudolph Motors. We argued that with testimony and with the argument, and the jury agreed. And we sustained, 3 weeks, and before that, years of discovery and litigation to get to that point. And that's what Toyota and Columbia are all about. You don't require the parties to go through this intense process and get a jury determination only for it to be set aside on invalid grounds.
You're saying that if we agree with you that the trial court could just come up with a fifth reason, and then we could go back through the whole process if we challenge come up and we say, no, that's not good either, and then they go back down and maybe a sixth reason?
Sure,
There's
yes.
no ends to this until the trial court gives up or the parties do?
You know, if the trial court is going to grant a new trial on invalid grounds 10 times, then we'd be back here 10 times. I think at some point, the court would understand that what you have said is that trials mean something. There is a constitutional right to trial by jury in cases like this, and it is not for a trial court to override them based on invalid grounds. Now, if the trial court had a valid ground, I can't see where there would be one in this case. That's a different animal. But that's not the case here.
Trial courts could just hold back, I mean, if there's no new development in the case, why would a trial court be able to whip out a new reason after all of these proceedings? I'm having trouble understanding why that would be the case.
You know, I hope the answer would be they can't, but procedurally, I think procedurally, if we prevail with this writ of mandamus, it puts it back to the point after the jury's verdict. And then the parties, they wouldn't be able to make these arguments. I can anticipate they would make other arguments. The trial court shouldn't do it. Maybe it's a stop. I mean, you could envision writing an opinion at some point that puts an end to the repeated issuance of invalid new trial orders. I could see that if you see that that's the pattern. But right now, just dealing with what we have in front of us, I think under this court's precedence, those grounds are not valid. And this court should issue a writ to compel the trial court to vacate those grounds.
Any other questions? Thank you, Mr. Jefferson. We'll hear from the real parties.
May it please the court, Ms. Pruger will present argument for the real parties in interest.
May it please the court. To address what you've been asking about, Justice Young, we are here because of the line of cases that this court has come up with since 2009 in Ray Columbia, in Ray United Scaffolding, in Ray Toyota, to present a standard and balance the role of the jury, the role of the trial court judge with that distinct observational vantage point in the trial court, and the review by the Court of Appeals. To maintain that balance, this court, through the trilogy of cases, has developed the proper standard for reasons for a new trial. And you did not hear opposing counsel fully address that standard or what standard should apply here. The standard that should apply is that the reasons are reasonably specific, cogent, that it's a legally sound basis, and that those reasons are matched by what's in the record. When you look particularly at the reason that was discussed during opposing counsel's testimony, the improper injection of testimony by Dr. Wimbish, first, the trial court did not conclude that was invited error. There are some comments during the extensive discussion that displays how disturbed the trial court was about the injection of that testimony. But the trial court does not determine that was invited error. And when you look at the list of questions, it's clear that plaintiff's counsel was asking the witness about alcohol consumed that night, outside of any concerns about a motion in limine. And what he injected was the concept that the plaintiff is an alcoholic, that she certifies that she wakes up in the middle of the night and has to have alcohol to go back to sleep.
Well, that is true, but the district judge gave one heck of a curative instruction. I mean, I almost read that and thought that the jury at this point is just going to regard that expert witness as so far outside the pale that everything else he said might be disregarded. It's pretty powerful response by the district court to the jury, was it not?
It was a powerful instruction to the jury, but as we create this balance, there has to be some discretion and deference provided to the trial court as part of being the observer in the room. Yes,
If
Justice.
if we agree with you that the trial court could conclude that the evidence was improperly admitted and the instruction didn't really ameliorate that testimony, here we've got a no liability finding for Rudolph Mazda. So how did that testimony, affect the determination that there was no premises liability, there was no direct liability? In other words, even if we agree with you that that could be a proper basis for a new trial, why would it be the basis for a new trial against Rudolph Mazda, Rudolph Motors, RM, because the jury's finding there of no liability wouldn't be something that would be infected by the potential contributory negligence of the plaintiff.
Here, the injection of the testimony, when you look at the reason given by the trial court judge, it's that it is so improper that it affects the trial and the verdict in terms of the suggestion that here we have a plaintiff that's a hard worker, there's been no contrary testimony, and the idea that suddenly this is her fault. I think a trial judge, particularly there with that vantage point, can having seen, not just given the instruction, seen the reaction of the witnesses to that improper testimony, having also given that instruction, but also seen the reaction of the witnesses to that testimony, it should have the discretion to make those decisions. And I would point, Your Honor, to the dissent of Justice Alley, because I do think this is important. When you look at what Justice Alley is saying, first, he doesn't think it's invited error. He thinks it's improper in terms of its insertion in the courtroom. Where he takes issue is with the instruction. But when you look at the standard that he offers, he looks to Rule 44.1, which is the traditional appellate standard of review. What he's not looking at is considering how this court has always crafted this line of cases in terms of recognizing the difference between the trial court and its basis and how it is allowed to set aside a verdict under Rule 320. This is in Re Columbia. A discussion, or starts there, a comparison of the trial court and what is the trial court's basis for being able to set aside a jury verdict and what is the appellate court's basis. That's Rule 44.1 versus the discretion provided to the trial court, the concept that your trial court doesn't have a cold record in front of it. Instead, what your trial court has, they are there to observe. They have that observational advantage, and they can make decisions about a new trial on their own motion. Whereas an appellate court has to receive the points of error raised by the parties, has a cold record. And so with that distinction between those cases, particularly a cite to that legal standard in the Rules of Appellate Procedure 44.1, is about a judgment. And that the application of that standard, where you're looking at all of the jury evidence and not providing any deference to the trial court and rendering irrelevant the trial court's position at trial to view all that's going on in the case. And particularly, I think Justice Alley's dissent highlights he was not there at the trial. He's seeing the cold record. And he, in his estimation, that instruction given to the jury was enough. But where is the discretion for the trial court who was there and saw what happened at trial to be able to make that determination? How is Justice Alley not simply second-guessing the trial court?
What in the record would support this other than the judge just saying, well, I don't think it's enough? There's a verdict that actually supports the plaintiff, et cetera, et cetera, et cetera. What in the record could we possibly look to? Or is the answer, there is nothing, and that's why we have to defer to the district judge?
I would say there is not something direct in terms of a statement from the trial court on the record in that sense. But when you look to, it is supported by the record, because when you look to that lengthy, it's pages and pages of the trial court judge He says disturbed 3 times. He certainly expressed, as we have included in our oral argument exhibit, that he's concerned, and to your earlier question, Justice Young, he has no interest in, this is the last witness, and he is concerned about granting a mistrial at the very end. We've also included in our oral argument exhibit, because I think it's worth noting when you read through that portion of the record, several pages, to really see how concerned the trial court judge is about this testimony being injected. And it includes a statement that we've provided from defense counsel as part of this back and forth, which suggests, gives your instruction, well, I have it here, and I understand that, but we've come so far, Your Honor, my apologies, exhibit 2, the very last box. And I understand that, but we've come so far, Your Honor. I think this instruction where it says you've already decided it's not probative, not relevant, disregard Dr. Wimbish's testimony on that issue, and then we leave it alone and get this case to the jury so they can render a verdict. And then obviously, well, we'll, can decide about that afterwards. And when you look at the concern that the trial court had and seriously considered granting that mistrial, that is supported by the record with the idea that the trial court thought the instruction was simply not enough. And that's where it's important for this court, as it is, we maintain all 4 reasons in this new trial order are supported by the standard initially begun in Red Columbia, given additional scope and explanation in United Scaffolding, and then under certain, you want to check, as is discussed, a merits review, as is discussed in Ray Toyota, but only so far as seeing that is supported by the record and not squarely conflicted. And in all of those cases were not about curtailing the discretion of the trial court. Those cases were about providing transparency and asking the trial court to provide its reasons for why it was granting a new trial, because previously there was no review. And when you're trying to protect that trial court's discretion and the role that the trial court has, but also protect, in that balance, protect the role of the jury.
So in that balance, there's an interesting distinction, it seems to me, between what the trial court's doing at the initial stage where the question is mistrial or curative instruction, because there's a veil of ignorance there. The court doesn't know what the jury is going to say. And so you might imagine a better argument for pure discretion in that context, as opposed to post-verdict, the court knows what the jury has said, and then there's the risk that the court's analysis of whether the evidence was too prejudicial is influenced by the court's own assessment of the evidence and sort of surprise at what the jury has found, and it bleeds into more of a great weight and preponderance kind of a thinking, rather than, because the veil of ignorance is gone, you know what the jury's done. These seem like different situations, and I wonder whether the discretion ought to be different given what the judge knows at the time the decision's being made.
And just to make sure I understand your question, should that treatment of discretion be different depending on whether there's been a decision before the jury verdict to decide that the evidence was so improper, or a decision after the verdict? Yeah. I think that the discretion standard is the same, because there is still an importance in looking to the trial court judge as not part of the cold record there at the trial and observing there, because the trial court judge may not know until after the jury verdict comes in that the instruction was, he may have a sense based on what he sees in the courtroom, but there may be other aspects once you've received that verdict where he confirms his worst fears, his suspicions. And I think the trial court, it's still that same balance. And you look at what in Ray Columbia, United Scaffolding, and Ray Toyota have all laid out. You look at the reasons. Has he given a basis? Has he explained what those are? Is it reasonably cogent? It doesn't need to be a pool-like standard where you explain all of your reasons and bases. And I would note for the court, part of the development in United Scaffolding of why you don't require an extensive, detailed list pool-like standard is because, again, of that balance between how you look at the jury, how you look at whether the trial court decides to set aside a verdict or whether the appellate court decides to set aside.
If the trial court had denied the motion for a new trial, what would be the result on appeal in connection with the improper admission of the testimony in this case?
I would anticipate it would be an error on appeal. And also an error that would be raised about the propriety of failing to grant the mistrial. And I think you would still be looking at an abuse of discretion standard, but more in the context of a standard appellate review of that abuse of discretion standard, which would differ from the deference that this court should apply here in reviewing, because this is a mandamus review of a motion for a new trial in terms of an abuse of discretion standard and how we look at what has gone on at the trial, guided by Columbia, United Scaffolding, and in Ray Toyota, should be focused on acknowledging that the trial court has not a cold record, but has been a part of the proceedings and has seen the reactions of witnesses and been a part of the trial.
So I have a question about something I think you said earlier, which was that the trial court did not find that the error had been invited. I had a note that the record, the trial judge in fact said, so you invite the error and then you want a mistrial. Is that something that was misattributed to the trial court, or did the trial court later make a different finding?
The trial court did ask a question of nature, and I believe that is a statement in the record. But the idea that the trial court, in fact, found later, if you look in terms of the record and the back and forth, the trial court judge seems to step away from that concept. And again, I would note, even in Justice Alley's dissent, he doesn't find that is invited error. And I think when this court looks at the record and at the questions, her questions were about alcohol consumed that night. That is consistent with what was a part of the motion in limine. And the answer that is given is based on a statement from a deposition that was never part of the testimony at trial, a statement from the deposition of a witness who said something akin to, somebody told me that Ms. Villegas said she drinks alcohol at night to fall asleep. And as is evident from the record, the trial court judge was extremely disturbed by that and its injection at that late hour, the last witness of the day, and a witness that is a forensic toxicologist, a witness who, based on the CV that was admitted, as well as statements to the jury, says that his, part of his work involves working with organizations that work with alcoholics. And he's already, this is on cross-examination that this response is elicited, and he has already explained in great detail about alcohol and number of drinks and his expertise in determining people's blood alcohol percentage, as well as looking at their drinking habits.
Back to Justice Blacklock's question, could one valid reason for the trial court to wait to make a decision on a new trial until after the verdict, after having given the curative instruction, be that it could turn out to be harmless if the jury didn't put any liability on Ms. Villegas? It seems like that would be where the harm would normally manifest. If the jury was disregarding the instruction not to consider that testimony, then the jury might think, well, we should put more responsibility on Ms. Villegas for some reason. And if it turned out they had put 0 on her, then maybe that's some indication to the trial court that there wasn't such an effect. Of course, that's not what happened here, but
Right.
Could that be a reason why the trial court might want to wait until after the verdict comes in order to make this call?
I believe so, and I believe the record reflects that when you really see the struggle that the trial court has in trying to decide about this mistrial. It's pages of trying to decide about this mistrial, and again, this is the cold record. none of us were there at the trial. But also, you don't, having read the record, you don't see that same difficulty or concern on the record over other decisions. And so, yes, I think that certainly the trial court gave that instruction, hoping it solved the problem, but then concluded after the verdict came in that it didn't.
So in the abstract, aside from this particular issue, but if a conscientious trial judge says after a long trial, a verdict, I have to have a new trial, presumably that trial judge has reasons, we require them to be expressed. If it turns out that they're wrong, would not that conscientious trial judge be happy to learn, no, the trial was okay. I don't have to reinvest 3 weeks plus all of these other proceedings in doing this. It was okay. That's good news, is it not, for the trial judge?
When you say, and again, to make sure I understand, when you say that the trial court finds out the reasons are wrong, it related to Justice Busby's question, I guess, because when the trial court has to list its reasons.
Yeah, I'm speaking just purely in the abstract, not even necessarily about this particular case, but just in general, a trial judge says, here's why I think a new trial is required. So now I'm prepared because I'm a diligent judge. I'm going to go ahead and invest 3 weeks, 6 months, whatever it is, into the trial. Court of Appeals, Supreme Court sees what the reasons are and can say, no, that reason is not a correct reason to think that your trial was so infected with error that you must redo it. Is that not good news for the average district judge, county court at law judge, to hear, okay, great, I thought I had to do it. I was making my best judgment that I needed to do a new trial. Thank goodness. Would that not be cause for opening the bottle of champagne as opposed to being sad?
Right. No, I now better understand your question. Yes. I think, especially in this record as well, there is not a situation where trial courts are excited, looking forward to, especially when they've lived through the trial. And again, you see this in the court's cases talking about why the power, the broad discretion is a part of what the trial court has to grant a new trial, because they are not sitting there looking for reasons to order a new trial. They provide those reasons. This trial judge provided those reasons, and contrary to what opposing counsel has stated, they do in fact meet the very clear standards in...
But one of those standards should be if they're wrong, then it wouldn't, so that's not cool, that's just,
correct.
Is it an error?
Exactly
so
correct.
You've got 4 reasons that the whole, we've now been 15 minutes or so into it, it's all been about one of them.
Yes.
The other 3 are not, as I understand it, going to be affected by the same question of cold record, what was the demeanor, they're more legal questions. Did Painter affect this? Can we reallocate the the liability? Were the non-economic damages potentially overlapping such that we can say, no, that's the kind of thing that's just not a good reason for a new trial. We can solve that as a legal matter. Do you basically agree that it's the Wimbish testimony that provides the key focus? Is that why we've spent now 35 minutes?
I think the Wimbish testimony provides the key focus, and I agree with your point. And also the Wimbish testimony is a most clear example of why the standard of what's in place in these cases, Columbia, United Scaffolding, Toyota, to your point that if it's simply wrong, that was the situation with Toyota. It was a square conflict. It wasn't the defendant that opened the door for limine, it was the plaintiff. End of story. But that is, this case provides the most clear example of a standard, whereas the others can be addressed on.
Does it reduce to the Wimbish testimony whether or not we think, as a matter of law, that given the curative instruction, given the verdict that supported the plaintiff, et cetera, that was an abuse of discretion, would be an abuse of discretion to order a new trial? Can we basically set aside the other 3 grounds and focus on that or not?
I think you can, particularly because the order talks about these reasons being collective, or they can be looked at collectively or individually. I would also note that the part of what's also addressed in the Dr. Wimbish testimony, in addition to suggestion about the jury being incorrect related to liability, is that the damages are too low. And so there is standing alone, the Wimbish testimony would be a basis to deny the mandamus and maintain the grant of a new trial. But because of the way the order's worded.
Any other questions? Thank you, Ms. Berger. Mr. Jefferson, you have 5 minutes.
This court is either individually presided over or, as appellate judges read, probably thousands of records combined. And in those jury trials, you will see time and again, objection sustained, the jury is invited to disregard. I mean, this happens all the time in just about every trial. If this instance here, where not only did the trial court say the objection essentially is sustained, but then read an instruction to the jury that called him unreliable, not credible, you can't believe a word he says. If that is not enough to cure any error, then, as I said, the idea in Columbia and scaffolding and Toyota goes away. This is the template now for a new trial that overrides a jury's decision, Justice Bland.
Does the other side of that coin, if we're not going to uphold a trial judge's policing of improper testimony, say to any lawyer, go ahead and put it in, because at worst you'll get an instruction to disregard the evidence, and they won't really be able to do anything about it on appeal or with the trial judge to declare a new trial?
So I don't think so, because the instances in which an instruction won't cure are rare. This court has said that an instruction cures the error, and this court has said jurors are presumed to follow the court's instructions. And here, that's exactly what they did.
But because of that, are you just saying that a request for a mistrial just simply isn't a remedy anymore for most improperly admitted testimony?
I think that most judges are going to do the right thing if the testimony is improper. But the court is also going to decide, is the admission of that testimony, did it cause, and this is the standard, the rendition of an improper verdict or judgment? And here, there's no evidence that it did. In fact, the evidence is contrary. What they're saying is the evidence is so devastating that it was going to gut the plaintiff's case. But what happens is the jury found for the plaintiff to the extent of $4 million and awarded damages in every category. And so this was not prejudicial to the verdict,
not
or the
damages
judgment.
for disfigurement or
Well, we can
loss of
discuss those.
services.
There's
No, but there were some damages that were not awarded.
Yes, but this was this is a plaintiff's win. The plaintiffs prevailed here. So whatever testimony came in this 3-week trial did not gut their case, which is kind of the picture that they're trying to paint here. And the instruction did, if it was error, the instruction did cure it, and it was an instruction that is over the top. You know, I mean, in some ways you could say this, you know, if a judgment is against the defendant, there's an argument that this instruction went too far in calling this witness completely unreliable.
If the testimony happened in a trucking accident case and the testimony came in that the truck driver drank himself to sleep every night, same result to obtain?
So if an instruction like this one is given, it cures that. Yes, the same, because this is not an appeal to race. It is not calling somebody a perjurer. It does not fit.
You don't even need an objection for those sorts.
Right. Well, this is what they're saying here.
Well, this was objected to.
Yes, but they're saying here that you didn't need an objection and that the instruction could not have cured that admission. And I'm just saying, think about the overall picture. Think about the thousands of trials that we have all the time, and evidence does come in, and sometimes mistakenly, and the trial court says, jurors, you will disregard, and maybe poll the jurors and make sure that that's true. We presume the jury is going to follow that instruction. Here, the evidence shows the jury did follow that instruction. The jury
How
found
do
for
we
the
know that
plaintiff.
when how do we know they followed the instruction when they put 30% on Ms. Villegas?
The presumption that this court has adhered to.
Well, I realize it's the presumption, but you said the verdict shows that they followed the instruction, and
Because-
I'm wondering how it does that.
Because the jury found for the plaintiff to the extent of $4 million. And they don't complain, they don't say that finding of 30% was against the great weight and preponderance of the evidence. The evidence here is that the plaintiff walked into the path herself of Mr. Ruiz. That is negligence in itself. So it is explainable on that, and no ground in this motion for new trial says, oh, this finding was against the great weight and preponderance of the evidence. There's evidence to support that. So the jury's finding is rational. It's based on the record, and each one of the arguments for granting a new trial is flawed and under Toyota, and that precedent the writ should issue.
Any other questions? Thank you, Mr. Jefferson. The case is submitted, and the court will take a brief recess.